You cannot take, you can take judicial notice that the document has been recorded, but you cannot take judicial notice of the fact and content of the document, the facts contained within the document.
Somebody
They
have
cannot.
to step in and support that, under penalty of perjury, would have to come in to support that title you're talking about.
Exactly. See, and this is,
Yeah, I got it, I understand it.
yeah,
It can't be entered into evidence until that's done, so they can't even talk about it.
no.
I brought it up in my case, I know it well now, Richard.
Look at this right here. An attorney and counsel shall have authority to bind his client in any of the steps of an action or proceeding by his agreement filed with the clerk. By his agreement filed with the clerk or entered upon the minutes of the court and not otherwise. That's the only time that he can bind his client. Then here's a substitute.
What does that mean, and not otherwise?
See, when they say not otherwise, there's no other options for,
I mean, it's
yeah, no other
only,
option. That's the only way that they can bind them.
yeah.
So-
They're coming in with these special appearance attorneys at the last hour, thinking they can step in and accelerate the case. So what Rich is saying is, make sure that you're objecting to the special appearance attorney coming in because he's not properly recorded with the clerk in the registry of action prior to the hearing.
Here's a
which is all
special appearance
hearsay.
attorney right here on
That's
284.
correct.
The attorney in an action or special proceeding can be changed or substituted in at any time before or after judgment or final determination as follows. Upon the consent of both the bank and the attorney filed with the clerk or entered upon the minutes. They never do that.
Yep.
Never.
Which is what I object to in the very first hearing. I said I object to the entire proceeding, object to the special appearance attorney under 283, 284, and 285.
Yes.
I haven't received any paperwork from
None.
him. I have not seen anything in the registry of action that he's checked in with the clerk. I'm going to object to the entire proceeding to move it further from
Yeah.
here out.
See, when an attorney is changed, as provided in the last section, written notice of the change and of the substitution of a new attorney or of the appearance of a party in person must be given to the defendant, or you, whoever, averse party. Until then, you can only recognize the former attorney, the original attorney that's on there, attorney of record. See, and they never do that. See, and people don't understand this, challenge this.
Which is why they keep the court reporters from coming into the departments so that they don't have a court of record so that you can appeal it, because automatically when there is no court of record, the appellate court automatically presumes by presumption on appeal that they have to affirm what the lower court said because there's no record.
Exactly. See here on 702, subject to 801, which is the testimony of an expert witness. The testimony of a witness concerning a particular matter is inadmissible unless he has personal knowledge of the matter. Against the objection of a party, such personal knowledge must be shown before the witness may testify concerning the matter. No attorney has personal knowledge, and you object to him testifying under 702A right off the bat. He has to show it, and you can cross-examine him. Okay, under 703, listen to
Which
this.
is why they're not coming in the court, they're
Yeah.
bringing the special appearance attorney.
Yes, that's why. It says, before the judge presiding at the trial of an action may be called to testify in the trial as a witness, he shall, in proceeding held out of the presence and hearings of the jury, inform the parties of the information he has concerning facts or matter. Oh, not this B. Oh, against, right here it is. Against the objection of a party, the judge presiding at the trial of an action may not testify in the trial as a witness. Upon such objection, the judge shall declare a mistrial and order the action assigned for trial before another judge. And they do this all the time. They testify.
That's what he has.
Yes. See, these are things that people don't understand and know when you go into the courtroom, and how to be able to stand on these and raise them up and have them there. See, because we pull these actual codes, and we have these actual codes that are certified to be able to take them and put them inside in front of the court, so the court has to abide by it. We ask the court to take judicial notice of these. See, now, let's go back up here. We got an attorney. You got an attorney that goes in before the courtroom. You just object to him. Against the objection, he has to be cross-examined. Now, if the judge is going to let you do this, what you're going to do is you're going to say, Your Honor, I'd like to ask him a question. I'd like to ask the counsel a question because I'm going to object to him testifying. Now, if he allows you to, first and foremost, what you want to do is state your name for the record, what you have, and I'd like to have him sworn in. You want to have him sworn in because before he can testify, he has to have, under 710, Evidence Code 710, which I'll show you in here, every witness has to swear in. Okay, so now he swears in, and you're going to ask him, do you recognize this document, which is going to be the complaint? Okay, you're going to ask him, do you recognize this document? He's going to say, yeah, it's a complaint. Okay, is your signature anywhere on this complaint? He's going to say no. He says, could you please tell the court who filed this document? He's gonna say the other attorney. I says, well, did you verify this complaint? No. Okay, see, right then and there, you're gonna impeach him. You're gonna bellow destroy him because he has no personal knowledge. He didn't verify the complaint.
1,200, that's hearsay.
Under hearsay rule, but you're asking him these questions here. But let's say he's the attorney of record, and it says signature on there. You verified this complaint. Could you please tell the court how you verified this complaint? Did you sit down and meet with anybody from the bank? Yes. Or no? He says, well, did you talk to him on the phone? Yes. I said, well, do you know who you were talking to? Well, that was, such and such. I said, well, I'm going to object to that statement. It's hearsay, Your Honor. Did you receive any documents to verify this complaint? He said, yes. By fax, email, or courier? He might say courier. I said, okay, well, I said, when you looked at them, did you know if they were originals or copies? He goes, well, I'm not. Well, Your Honor, I said, I'm going to object to that because it's going to be hearsay, and if they're copies and he doesn't have them here with the court to be able to show them, then it's inadmissible evidence. It's hearsay.
There's nobody here to support him.
So that's how you want to destroy. You've got to destroy these people inside the courtroom. You know, when you go inside there, the first thing that you want to do when you walk in there, good morning, my name is so-and-so, I'm the defendant in this matter, and I said, I'm going to object to the proceeding moving forward due to lack of ratification and commencement on 367. Now, 367, if we're going to look at that, it states, let me show you this here. It says, every action must be prosecuted in the name of the real party in interest, except as otherwise provided by statute. Okay? That's what it says, every action must be prosecuted. And see, what we're doing is we're walking, we believe that every time a complaint is filed within the court, we're believing that these people are the ones that had a right to bring it against us, you know, or that we were dealing with, or they have been assigned some kind of authority or right, or they're in the right capacity. But if you do not raise an objection, it's an objection waived. That's why from the moment that you walk into the courtroom, when you raise that hand, you're objecting to the proceeding moving forward, and you're going to do it under 367, lack of ratification and commencement on 367, because you're led to believe at this point, Your Honor, that they are not the real parties of interest to bring this claim. But I'm going to hold that objection for what reason? I'm holding that so that I can build my foundation to prove to the court why it should grant my objection. Okay? I'm going to show the court. And I want to move the court to take judicial of its own court record. I want the court to look at the court record to see who's appeared before this court, who's filed this complaint, the complaint that's on file with this courtroom, and who allegedly verified the complaint, which I'm objecting to at this point, to be used as evidence under 1401A and B of the Evidence Code. Is the attorney that filed that complaint here before this courtroom? No. It states here in the caption that it's either Wells Fargo, Deutsche Bank, or whoever. Is that person here? No. Is the party or anybody that represents that person from that company here? I'm not talking about the alleged special appearance attorney or the counsel, Your Honor. I'm talking about somebody that has personal knowledge of the matter from that company that can testify under penalty of perjury before. Oh, no. Okay, now.
That party of interest is what you're talking about. That person has first-hand knowledge. That's the party of interest.
He has to have first-hand personal knowledge.
But that's the guy we're talking about.
Yes. And if he comes before the courtroom, then you have a right to cross-examine him and ask him questions, because he can say, you know, I work for Wells Fargo Bank. And he says, okay, could you please tell the court what department? I work in the mail department. Oh, delivering mail? Oh, yes. See, but you need to find that out. You need to find out who he is, what's his background, and what he's brought to the court to prove that he does work for that company or that institution, what paperwork he's brought there to verify and validate the complaint that he's filed here before you.
We're trying to shift to.
Right.
And as well as the county recorder's office, which confirms that they never had the original. Because you can't have the original while the note is still trading on Wall Street.
Exactly. See, you cannot. See, while it's there, it cannot be here. So you have to establish their right to be able to bring the matter before the court, because they're coming to the court. See, and this is the problem, because we're waiving our right. We're coming in with the laws and the statutes, all this other stuff, and we're led to believe that we're entering into a legitimate, lawful entity, but it's operating under color of law, and they're using discretion, not facts or evidence. And that's why I'm saying that when you're in there, the first thing you're going to do is object to the complaint being used as evidence under 1401A and B, the Evidence Code, and then you're going to object to the attorney or counsel testifying in the courtroom under 702A. You're going to ask the court, is he going to testify? And if he's going to testify, He needs to be outside the courtroom while you're giving testimony before the courtroom. If he's gonna be a counsel, then he can stay in the courtroom, and I have no objections to him stating his name. But if he states something else, anything other than that he represents that, then Your Honor, I'm gonna challenge and object to that, and I wanna see facts and evidence to support any allegation or statements that he states before the courtroom. See, we've just become so lax, and we didn't know all these things. We had no knowledge about how the chess game was being played. See, and they were not gonna tell us, you know. We've watched people play it, but we thought, okay, we can play, but you're not gonna win. See, and we need to understand this stuff.
You know, now that you say that as well, anyone who's proceeding in any hearings where there clearly was no presence of the plaintiff who filed the complaint, and the special appearance attorney basically gave testimony, he's now a witness.
Yes.
So in fact, he
Has to
cannot
step
come,
up.
exactly, he can no longer come into that courtroom.
Yeah.
In fact, he has to be sworn in.
Right.
Because he's given that
Yep.
testimony.
Yep.
And now someone new has to sub in.
Exactly. See, these are the things
We'll
that we don't-
continue this in 30 days.
Well, except the court, well, I would ask you, I
Because
would
they
have,
gotta find another special appearance
Yeah.
attorney.
and I would have said, objection, Your Honor, at this point, I said, I'm gonna move the court to dismiss this case for failure to prosecute this matter, and I'd like to have them come properly before this courtroom. In the event that the court doesn't do that, and the court moves the court will be practicing the law and moving ultra virus against me. As I'm appearing, I've appeared at every hearing we've been here before this courtroom, and I have personal knowledge of the matter. There has not been one person before this courtroom that can testify to the validity of the complaint or the allegations listed within that writing.
It's a mistrial.
And I would ask the court, is this a writing, considered writing? Okay, I'd like the court to confirm, can we all, concur that this is a writing? So therefore, I'm gonna object to it being used as evidence under the 1401 A and B, the evidence code, because it cannot speak for itself, nor can it self-authenticate itself. I cannot cross-examine or ask questions. So therefore, it's based on hearsay, and it's not self-authenticated, so I'm gonna move the court to strike it as evidence before the courtroom. And then move it to either hold them in contempt and file a sanction against them for failing to appear and to be properly before this courtroom. Okay, now the court has, at that choice, it's gonna have to either dismiss the case or it's gonna move the court case, but you've gotta have your court reporter there to make sure that you can take it, because the moment that they do, then what you've gotta do is you gotta take it up on a writ and take it up on a writ of supersedes. You've gotta take that up immediately, okay? And then you're gonna start filing
I'm gonna
complaints
say,
with the Judiciary Committee.
I object, Your Honor, because under the Federal Rules of Evidence Code, this is the hearsay under 1200, because it has been met, the conditions of evidence 1401A and 1401B. There's nobody here to authenticate it or certify that evidence. Nobody here to support it, so I object under 702, because nobody here, and therefore it's hearsay, 1200.
Yeah, 1200 is hearsay.
Is that correct what I said?
Yeah, what 1200 is, and the 702 is lack of personal knowledge.
Yeah.
702 is lack of personal knowledge, so what you
Yeah.
do is you automatically put them in that predicament because you understand the procedures, you understand the evidence rules, you understand the
702? No, I mean, they're really good. So I think I'm gonna put them up. Look at all the stuff I added.
Oh, yeah,
I added 1401, all that stuff,
yep.
a whole bunch of stuff.
If there's something that you really wanna emphasize with the court, you really want the judge to know, Your Honor, can I take a moment? I'd like to ask the court reporter to read back that statements and the things that we raised to make sure that I have that for my reversible error and appeal, just in case, but I'd like to make sure that that's been taken, and you have them reread it back into the court, she reads it. So now he
that's
hears and
good.
knows what you're going with
Yeah.
that stuff, so, what, they don't wanna be,
But there's no
Appeal.
court reporter there.
no,
so
but you wanna bring your court reporter, that's what I'm saying.
But I'm thinking it would be good to say to the judge, could we have the court reporter read that back?
Yes, that's what you
And
want.
there's no court reporter. He said, well, we have no court reporter. Thank you, Your Honor.
Yeah, but then see if they
You-
says.
And
if
you
they
look
don't
at your
follow it,
you look at your witnesses. Did you take note,
Yeah.
grand jury?
Yeah. But you know what's gonna happen, see, a legal court reporter will still stand above the witnesses. They'll, in the upper courts, they take the validity of the judge, his comments, and compared to like yours or somebody else's, but you'd have to go to the Judiciary Committee, you have to file complaints all the way around. See, but my thing is that you really need to understand this. If once you understand this, you stand a chance.
I'm getting there.
Yeah.
I'm not there.
No,
I'm
but you're
there.
getting there. But the thing is that
Getting there.
we really need to understand that when we walk into the courtroom, because you have checks and balances, and the judges, they don't really know what to do because they're not accustomed to having you inside there. like that with somebody that comes in and understands their game. See, because you stop them from using their own discretion. I'm stating I want the facts and conclusions of law of why you're overruling my objection, because that's why you want to build a foundation. So when you do an objection, you're telling the judge, I want to hold my objection because I'm not going to give you the right to use your discretion. I'm going to show you why you're going to have to grant my objection. I'm going to build a foundation to show the court why he should rule in my favor. That's what you have to do. See, and the people don't understand this. And they haven't gone through this. They don't understand how to present before the courtroom.
Have you told them the difference between an attorney and a counselor?
No.
I asked for a 402 evidentiary hearing.
Yes.
I says, no evidence in this case. The facts are facts to support this cause of action. The evidence of facts to support his allegations, the plaintiff's allegation, the property was sold in accordance with Civil Code 2924, as Mr. Block said. He claimed the evidence of all the elements of